and we will make America great again. Thank you, Michigan. Go out and vote. Go out and vote.
What does it take for a former president to be declared ineligible for office? This is the question currently shaking the political landscape in Colorado. In the heart of the Rockies, a political storm is brewing. A group of Colorado voters is challenging the eligibility of former President Donald Trump to appear on their state's Republican primary ballot. But why now, and why Colorado? The answer lies in the events of January 6th, a day etched in the memory of the nation. The infamous attack on the Capitol serves as the catalyst for this controversy. The Colorado voters argue that Trump's alleged role in the insurrection places him in violation of the Constitution, specifically Section 3 of the 14th Amendment. This provision, they contend, bars anyone who has engaged in insurrection against the United States from holding federal office. But as with many things in the realm of politics and law, it's not quite so black and white. Trump's legal team counters this argument, stating that the constitutional provision in question applies only to officers of the United States. They maintain that the responsibility for enforcing this provision lies with Congress and courts. This clash of interpretations of constitutional law and the boundaries of political accountability has ignited a legal battle that extends far beyond the borders of Colorado. The case, brought forth by 6 Colorado voters, could set a precedent that reverberates throughout the country, influencing similar cases in other states. The tumultuous political landscape in Colorado is a testament to the far-reaching implications of the January 6th attack. The legal standoff is as intense as the political one. It's the Constitution versus interpretation, with the Supreme Court in the middle. Now let's delve into the arguments from both sides of this legal tug-of-war. On one hand, Colorado voters who are invoking Section 3 of the 14th Amendment, a provision that rarely sees the light of day in courtrooms. This section essentially bars anyone who has taken an oath to support the Constitution, but later engages in insurrection against it, from holding any federal office. The voters argue that former President Trump's actions leading up to the January 6th attack on the Capitol constitute such an insurrection. On the other side of the aisle, Trump's lawyers are not sitting idly by. They counter that the 14th Amendment Section 3 should not apply to Trump. Their argument? This constitutional provision is meant for officers of the United States, a category they claim does not include the president. They further argue that enforcement of this provision falls under the purview of Congress, not the Supreme Court. This case isn't just about legal semantics, though. It's about the interpretation of the Constitution and the limits of presidential power. It's about whether a president can be held accountable for actions that some see as a betrayal of their oath of office, and others see as within their rights. The Constitution is not a static document. It's meant to guide us, but it also allows for interpretation and adaptation. And that's where the Supreme Court comes in. As the final arbiter of the Constitution, the Supreme Court has the power to shape the interpretation of these laws and, in doing so, shape the future of our democracy. So what we have here is a high-stakes showdown, a legal chess match with the highest court in the land as the chessboard. It's a battle of legal wits, with the balance of power hanging in the balance. The Colorado Supreme Court made a decision, but the final say isn't theirs. The ball is now in the court of the highest judicial authority in the land. In the heart of the Rockies, the Colorado Supreme Court made a significant ruling. 6 Colorado voters challenged former President Donald Trump's eligibility to hold office, citing his involvement in the January 6th Capitol attack. They argued that this act constituted insurrection against the U.S. Constitution, and thus, Trump should be barred from federal office under Section 3 of the 14th Amendment. The Colorado Supreme Court agreed with this perspective, ruling against Trump. However, the story doesn't end there. Despite this decision, the Supreme Court's hearing is yet to take place. Until then, the Colorado Supreme Court's ruling is on hold. Now, why is this? The U.S. judicial system is structured in a way that allows for appeals, particularly for cases of such magnitude. This structure ensures that every argument, every piece of evidence, and every legal nuance is thoroughly examined before a final decision is reached. In this case, the final say belongs to the U.S. Supreme Court. Trump's lawyers, on the other hand, argue that the constitutional provision invoked by the Colorado voters applies only to officers of the United States, and that it's up to Congress, not the courts, to enforce it. This argument adds another layer of complexity to the case, emphasizing the need for a comprehensive review by the highest court. The Colorado Supreme Court's decision, although currently on hold, is noteworthy. It sets a precedent that could encourage similar legal challenges in other states. The ruling sends a clear message that the alleged insurrection against the Constitution is a serious matter, worthy of examination and potential penalties. But as we said earlier, the final decision rests with the U.S. Supreme Court. Will they uphold the Colorado ruling, or will they see things from a different perspective? The nation waits with bated breath. The Colorado Supreme Court has spoken, but the last word belongs to the Supreme Court. What happens in Colorado may not stay in Colorado. The Supreme Court's decision could have ripple effects across the nation. This is not just about the political future of one man, but it could potentially shape the way we interpret our Constitution. The Supreme Court's decision on the Colorado case could set a precedent for similar situations in the future. If the court rules in favor of the Colorado voters, it could mean that any political figure who is deemed to have engaged in insurrection against the Constitution could be barred from holding federal office. This would not only affect Trump's political future, but also the future of any politician who might find themselves in a similar situation. Moreover, this case could lead to a broader interpretation of Section 3 of the 14th Amendment. Traditionally, this provision has been thought to apply only to officers of the United States. However, the court's ruling could potentially expand this interpretation to include former presidents as well. This shift in understanding could significantly affect the political landscape of the country. Furthermore, the decision could also influence the way we view the role of the Supreme Court in enforcing the Constitution. If the court rules that it is within their purview to enforce the 14th Amendment in this context, it could set a precedent for the court's involvement in similar constitutional enforcement issues moving forward. On a more immediate level, the decision could also have implications for the upcoming elections. If Trump is barred from running, it could dramatically reshape the field of candidates and potentially impact the balance of power within the Republican Party. But beyond the immediate political implications, this case raises fundamental questions about our Constitution and how we interpret it. It asks us to consider what it means to uphold the Constitution and how we should respond when those who have sworn to protect it are accused of violating it. This case is about more than one state or one former president. It's about how we interpret and uphold our Constitution. This is not just a legal battle, it's a conversation about the fundamental principles that guide our nation. The nation watches and waits as the Supreme Court prepares to make a decision that could alter the course of American politics.